Ready? Don't forget to unmute. Ms. McDonald, we're ready when you are.
Good morning, Your Honor. May it please the court. My name is Tara McDonald from the Law Office of Robert Eckert and Associates, and I'm here this morning on behalf of the appellant, Dr. James St. Louis. Your Honors, we are here today seeking review of a July 27th, 2020 order issued by the trial court, finding that my client, Dr. St. Louis, did not qualify for the head of household exemption from wage garnishment under Section 222.11 and Section 77.041 Florida statutes. Your Honor, it's our position that based on the face of this order, the court committed reversible error in many different aspects. For example, if you look at the face of the order, the judge obviously used the incorrect legal standard in reaching his opinion. And what's important to note is this legal standard was clearly expressed to the judge prior to his issuance of the order. The legal standard that I'm referring to is the fact that a debtor does not need to have a legal duty or obligation to provide support to a family member in order to qualify as head of household. But the
expenses have to be paid to a dependent. So I follow you on your argument, distinguish between a legal and a moral obligation. But what is a dependent? I mean, I pulled out the dictionary just this morning, and it uses the term reliance when it defines dependent. One who relies on another. So, for instance, his new wife, while he may cover a certain amount of the expenses of the household, is someone who's making $400,000 a year relying on that, as opposed to someone, reliance can be a choice or it can be a necessity, but it was in her children who have the resources available from their mother. Are they relying on Dr. St. Louis?
So, Your Honor, I think that what needs to be looked at here is that he presented competent substantial evidence that he was providing more than one half of the support for not only Dr. Maxey, but more importantly, his adult college children. The law is very clear. He only needs to do this for one person. He doesn't need to do it for more than one. And so as long as he qualifies as providing that support for a minimum of one person, then he qualifies. The statute doesn't limit it in terms of amount of money that he makes or anything else.
Does the statute contemplate that the dependent is in the household, by which I mean in the house?
No, Your Honor, because if you look at the case law interpreting this, there's no requirement that they live in the house. For example, the Mazzella case that we reference in our brief and that was presented to the trial court clearly did a complete analysis of this and found that as long as for example, it's a child who's your adult child in college, that clearly qualifies as providing support. And so those children don't necessarily need to live in the house, especially if they're attending college, as long as they are, he's providing more than half of their support. And the record in this case is clear that he was doing that. And the case, if you look at the Mazzella case, for example, in footnote—
Can I ask you how far you go with that? So let's assume the son is of majority, he's over 18, I assume.
Yes.
And he graduates from college and he sets up an apartment in whatever cities he's in, and dad pays for it. Is Dr. St. Louis supporting a household dependent?
Well, then I think that might be a little bit different situation. That's not the case we have here, though. The case we have here is these children that he's supporting, and he's actually supporting 3 of them. The affidavits and things, he says in his affidavit that he's supporting 3. He did provide more proof and evidence and an affidavit from one of them. But in this situation, they are still children in college. That's not something that's present in this case. So I don't think we need to go that far. And you have to recognize that Florida is a very debtor-friendly state.
So what are
And-
you relying on to follow up on Judge LaRosa's question? It sounds like you are entertaining the possibility that if this individual is no longer matriculating at an institute of higher learning, that the scenario might be different and he may not be a dependent.
Yes, Your Honor, I think that's a different situation. That's
So
not
why
something
the
that's
distinction? Why would you draw the
Because in
distinction?
that case, it's an adult who's out in the world who should be making their own way. It's not someone who's in school. And if you read in Mazzella, they reference the fact that Florida has a public policy in favor of fostering family and in favor of fostering and understanding the importance of higher education. If you look at the very last page of Mazzella, the court specifically says that in Florida, the Supreme Court has recognized a parent's duty to assist adult children in obtaining a higher education. That's increasingly necessary in today's fast-changing world is a moral one. Florida has a very strong public policy on fostering family and fostering, allowing people to help their family to obtain education and to, be successful. I mean, that's in the case law. I think that.
Suppose I have a boomerang child who's an adult and, the economy being what it is, comes back home to live with dad. Maybe that makes a stronger case for a household.
There is case law, actually, Your Honor, that says that, and I cited it in my brief. I can find the actual case for you if you would like, but there is a case where an adult, a mother moved in with her adult daughter and was providing more than half of the support for her adult, and they did find that qualified, and I can locate that case for you. I did cite it in my brief. So that's a little bit of a different situation as well. But
so let me ask,
yes.
Oh, go ahead.
No, it's okay.
Please finish answering Judge Lord's question. I apologize.
I think I finished it enough. I can jump back to it if he has.
So support for so it's a child or other dependent. So that language suggests to me that the child must be a dependent. So for his natural son, his biological son, are you placing him in the category of a child or an other dependent? In other words, does child have to mean someone who has not yet reached the age of majority? Or are you saying, someone's 50-year-old child because they're a son, they're a child? Or are you saying it has to be a child so that this individual must be an other dependent?
Actually, Your Honor, the case law has already decided that issue. That Mazzella case that I keep referencing went through
that's
that
a fourth
analysis.
DCA case. I mean,
It
they determined to be a child, yeah.
And they did. And Your Honor, the second DCA, although it's obviously not binding, but the second DCA has referenced the Mazzella opinion as if it potentially would be relying on it, but it obviously
In Baker was that?
But yes, in Baker.
It seemed pretty equivocal about whether it was something to follow or not. It said we're not going to decide, didn't it?
Well, what it said there was it depended on okay. In that case, what the court said is we're not going to decide whether this person still qualifies as head of household. They might because of Mazzella, but that issue wasn't before the court. So they referenced Mazzella as if they were like, okay, if she does still support this adult child, then she will still qualify. So that's what
I will grant you this. They did the panel there did say a child in college. Presumably he was someone who was reached the age of majority, and they still considered him or her a child. So go on. Sorry.
It's okay. I just think it's important to recognize that these statutes are interpreted in favor of the debtors. They are interpreted in the state of Florida in favor of family. I mean, that is a public policy of the state of Florida that can be seen throughout all of the exemptions that they have for
Well,
debtors.
if we're going beyond the text and talking about case law and talking about the purpose and sort of policy issues, isn't there case law that talks about the fact that the purpose is to keep these individuals, off the public dole? In other words, to actually avoid someone who, but for support from the head of the family, would be unable to support himself or herself? I mean, I'm not saying we should rely on that one way or the other, but if you are going to rely on the public policy espoused in opinions, how do you deal with that public policy?
Well, the public policy is to keep the family members off of public support. However, what is also in case law, it says that if the legislature wanted to limit this to people that were in that position, it could very easily add language to the statute limiting it. This statute has no limitations as far as how much money that a person makes, or how much money a person makes, or the status of the person that they're supporting or anything. There's no qualifying language in this statute. And so if the legislature wanted to take it that far, they could very easily cap this statute or put some kind of limitations in there that would then change its effectiveness. But instead, what the state of Florida has chosen to do is have a exemption from wage garnishment. If you are head of household, no matter how much money you make, or no matter what the situation is for these children, it doesn't have a cap in there. So I think
Since you brought this back to the Texas statute, which is good, I want to go back to my initial question, which was, what does a dependent mean? So, and to obliquely reference Judge LaRose's hypotheticals, I mean, at any given point, someone could choose to rely on someone, but is that a dependent? Doesn't dependent connote the necessity, meaning I can't make it on my own. This other individual is required in order to support me, and if not, I would be not supported at all.
While I recognize where your Honor is going with that, I don't think the statute is written in those terms. It seems to me, based on the case law that I've seen and the terms of the statute, it says child or other dependent. It doesn't have any limitation that, a dependent could be just someone that, you claim on your taxes because they live with you. How do you define the concept of have to? I think that the legislature is trying to make it simpler for interpretation, because if you try to make it something where you have to prove that this person has to rely on you or they can't make it on their own, that's basically simply a person like maybe who's on Social Security or has a disability, but it would cut off a lot of the other people that the statute provides protection for. Even in Mazzella, they did note that, this was a physician, it was a physician in that case as well, who was supporting her adult child. I think that if you tried to make it something that was that subjective, it would change the nature of the law in the state of Florida, which is that these statutes need to be interpreted in favor of the debtor, and that we are a very debtor-friendly state. We really are.
Going from the definition, or the category of the individual, could you talk about the proof that you adduced to establish that the provision was of 1/2 of the support? In other words, would you agree that doesn't just that would require a complete picture of all of the individual's expenses and all of that individual's alternative sources of income? And was that adduced?
Well, in this case, we presented evidence that that Dr. St. Louis was providing the general expenses for his. We only presented as far as one son. He did say in his affidavit he was doing it for 3 of them, but he presented evidence that he was paying for his lodging, his food, his travel expenses, his pretty much everything. The other side, the appellees, the only evidence that they submitted, really in contrary to what we submitted, was an untimely affidavit that did not follow the terms of the statute. It did not deny that he was paying for half of the support for a child or dependent, excuse me. The only thing that the affidavit that they provided alleged was that he did not have a legal duty or obligation. So the evidence that we submitted was the only evidence in the record really that addressed that issue, because their affidavit, the only affidavit that they filed, was not sufficient. It only raised that one issue. It didn't even say in the affidavit, we deny that he's paying half of the expenses.
You're saying it's unrebutted. Real quick, I don't want you to run out of time, because I do want.
Thank you. I do want to reserve. I did want to reserve a few minutes. I believe.
Okay, you've got about another minute if you want to reserve 5.
I'd like to
So
reserve
your procedural argument about the failure of the plaintiff to file a sworn response, and also that it allegedly filed it untimely.
Yes.
Where did you preserve that argument? Was that made at all below?
Well, as far as the initial writs that were issued and the initial notice of exemption that we filed, under the terms of the statute, we don't have to take any action to preserve that right. The terms of the statute specifically provide that.
You're saying that the clerk is to
Yeah,
enter.
it should be dissolved automatically.
So are you conceding that you did not it was not raised at all?
That issue was not raised there. However, regarding the fact that the affidavit was legally insufficient that was filed, that argument, I believe, is waived by the fact that we presented to the trial court the legal argument that the one issue that they raised was not sufficient. They didn't deny on the face of their affidavit the allegation that he was the head of household. They only made a legal argument in that affidavit. So on its face, it's not legally sufficient. So that, the fact that we raised the argument that it was not the proper standard of law, I think preserves that, because then the trial court should have recognized that that was not grounds to deny his exemption.
Okay, thank you.
Thank you.
Counsel, whenever you're ready, you can begin.
Good morning. May it please the court. My name is Shani Riveau, and I'm here on behalf of the appellee, the judgment creditors in this case. The history of this case is quite long and goes back pretty far, but it ended in July 3rd of 2019 with a judgment of over $360 million against the judgment creditor here. I want to start by referring to Judge Atkinson's, your question regarding the dependency issue, because I think that that goes to the heart of what the issues are here. Indeed, the appellee here, the judgment debtor, did not demonstrate that any of his family members were dependent on him, and none of them relied upon him. And that's supported by all the credible evidence. In fact,
there's a dicta obviously in Baker that says a child in college. Are you on the same page? I want to know where you are. This individual could be considered a child even though he's over the age of majority.
We don't dispute that. I'm sorry, Your Honor, I didn't mean to cut you off.
So there's Baker and there's the fourth ECA opinion, at least suggesting that courts have entertained the possibility that a kid in college, in air quotes, in college, could be a dependent. Would you concede that? And if so, what's your argument that this individual is not a dependent?
Sure. I would say that there can be circumstances when you can factually demonstrate that the child is in college and is dependent on your support for that. But here, that's not the facts that the court had in front of it. In fact, what the court did have in front of it was the support that he claims regarding his support for his children was a statement under oath that he had an obligation pursuant to a court order to supplement the 529, right? That's the court order from Judge Pollack. But when you look at the master settlement agreement, because it was enforcing the master settlement agreement, there was a divorce agreement that was the division of property between the husband and then ex-wife. And that 2019 agreement,
Can I cut you off? In other words, Judge Stevens focused on that and said, before I get to the question I want to ask you next, I want to say, try to short circuit and say, are you saying that because the judgment debtor relied on this marital settlement agreement as evidence for his obligation, that because the plaintiff undercut that adequately, that we don't need to consider the fact that, and now I'll segue to what I was going to ask you about. The statute says is providing. So let's say the judge and the plaintiff were correct that he had no obligation. So because, and let's say you're correct that, that was what the judgment debtor was relying on, and that was undermined by the plaintiff. Wasn't there evidence that he actually is providing, whether he has an obligation or not, more than half of the support for the child or dependent?
He submitted an affidavit saying that he has this court order. He didn't submit any evidence showing that he was making any of these payments towards it. But I think the more important thing is that just because he didn't pay this, didn't pay this amount back in 2014 did not transform him to the head of household back in 2019. And it's also important that the master settlement agreement itself was a division of assets of the husband and now.
I guess what I'm asking is this: let's say we agree that his obligations under marital settlement agreement did not make him the head of the family, but the statute says head of family is a natural person who is providing more than half. Let's say there was never a marital settlement agreement. Let's say he was never married and he had this child. And was there evidence adduced by the judgment debtor that regardless of his obligation, this individual, Dr. St. Louis, was providing more than one half of the support for this college student?
No, there's no evidence. He had his affidavit saying so, but no documentary support to support that. And I think this goes back to the question also of the construction when we talk about the statute.
Is that unrebutted evidence? Is that unrebutted evidence? Sworn affidavit saying my kid doesn't get any other money? And
no, well, Your Honor, what he actually, the affidavit, the other statements that he had, he submitted a form to the Bank of Tampa, which is a document that he had withheld previously, where they asked him for it's a personal financial statement, and actually triggered.
Couldn't that be construed to say, hey, I don't have to pay for this. I could cut him off at any time. I don't have an obligation. Or maybe he lied to the bank. I don't know either way. But is that per se inconsistent with, and you tell me whether there's evidence or not, evidence that currently he was providing more than half of the support for this college kid?
No, I don't believe he was. The fact that I believe what matters here is that the judge took the credibility of this appellant at issue, because the law in Florida is also clear that an honest debtor is the only one that is entitled to a liberal construction in his favor. And he's not an honest debtor. And the judge didn't have to wholesale accept his affidavit when there's contravening evidence. That form from the Bank of Tampa was also asked him about loan information, promissory notes, and also signed under oath. The judge didn't have to accept his affidavit simply when there's contrary evidence, and in fact made that determination that he wasn't credible, right? And the court also had before him a history of this appellant and a detailed pattern of withholding information, withholding documents, hiding bank account information, and in fact entered an order against him, prohibiting him from moving assets, from opening new bank accounts, from even requiring compliance with court orders one after the next, because he showed a simple, complete flagrant disregard for the court's orders. And here he's asking for, that everything that should be interpreted in his favor. That's not the case. The court found him not to be credible and relied on other statements. For example, when he says he's paying for one of his sons, in deposition testimony, which the court had in front of it too, and I think that this is the quote unquote affidavit, was not the only evidence submitted to the court. In fact, there was significant amounts of evidence submitted to the court. For example, in the reply brief in opposition to the notices of exemption, starting at the appendix at page 23, there's significant detail and documentation demonstrating the inconsistent statements and his deposition testimony, where he didn't say he paid for the college tuition. He said he was a co-signer on the loan. And now, as a co-signer on the loan, is that providing support for a dependent? That's not providing nor the support for a dependent. And indeed, he needs to be able to demonstrate both of those, both that he was a dependent and that he was providing that amount. And simply being a co-signer when he had never identified that information until his deposition. He had numerous statements under oath. He had to submit a fact information sheet, for example, which, because he had delayed in filing that, we had to file our first motion for order to show cause, and which so required 2 court orders just to simply get the information relating to his assets and his liabilities, and information regarding his supposed claims for exemption. And in those places, he didn't claim in his first statement, didn't mention anything about the 529, and he also didn't mention anything about the student loan. He even then filed an amended fact information form, and again didn't mention anything about this the student loan obligation, and for the first time mentioned this 529 order, but it's clear that that's not what was supported his actually providing support for a dependent. Indeed, there was no evidence that any of those kids that were already in college and whose mother was enforcing an agreement from 2014 required this dependency on this support, as opposed to just enforcing that agreement. And as it regards to his now wife, Dr. Maxey, he testified at deposition that she was not relying on his support. Specifically, he said she made enough money to support herself. She could afford all of her own expenses. That even though he had filed an amended claim for exemption, identifying this marriage, they never had any discussions on whether she would rely on him for any support. And in fact, at the time of his deposition in November, before these affidavits were filed, and I think that that's very important to understand, and why the judge could question the credibility of this appellant, despite even all of the evidence before it in all of these renewed motions for order to show cause, which you can find at the supplemental appendix starting at page 15. These affidavits came after his deposition testimony. At his deposition, he testified that he was splitting his time with his now wife between her house and his house. She then sold her house, and as she stated in her affidavit, she kept the proceeds for herself. She didn't share with that. She independently also has her own medical practice, where he's not a shareholder, not a director, not entitled to any benefits. There was no basis to say that he supported her. In fact, not only did he not support her, she paid for majority of the expenses at the wedding and even paid for their honeymoon. So the court had before it significant evidence, and not just, as counsel mentioned, some untimely affidavit, but significant evidence of sworn testimony in deposition, the sworn fact information sheet, the sworn amended fact information sheet, the sworn statement from Bank of Tampa, all documents that he had withheld and required multiple court orders in order to simply obtain. And in fact, I do want to point one thing.
Stop you for a minute. I got to stop you for a minute because I'm focused on something else and it's distracting me from your argument. Okay, you're litigating this particular issue, but to what end? Because as I read the statute, the garnishee has automatically been discharged from liability. How do you avoid that? Aren't you going to have to file another writ? And then what are you going to like litigate this when there's no writ of garnishment, there's no garnishee, it's been discharged, and then just say, oh, well, we already litigated this, so they can't file the exemption when we file a new writ?
Well, Your Honor,
I'm a little confused about procedurally where we are, because I don't know, when you have a statute that says the writ shall automatically be dissolved and the garnishee shall be discharged from further liability, what is the point of this argument? The garnishee is discharged.
Well, Your Honor, to answer your question, I think that this still needs to be an issue preserved on appeal. Indeed,
but isn't it theoretical at this point?
Well,
there's no writ. There's nothing.
Well, there have been subsequent writs that have been submitted, but.
And did you ever file a motion for final judgment within 6 months of any of those?
We did, as it related to the entity owned by the appellant, the International Spinal Surgery PA. But as to the 6 months, there are new writs where 6 months has not passed yet. Well, I do want to highlight
Wait, so those were before the trial court?
No, because this issue was never raised before the trial court.
So what you're saying is that the clerk never did not dissolve any writ.
Correct.
That did not happen. So
correct.
the point remains, so that there was, for either want of a timely response to a claim of exemption, nor for want of a motion for a judgment, right? Neither the clerk didn't dissolve the writ for either of those reasons, but and those procedural deficiencies were not preserved. However, is it jurisdictional? Is that something? In other words, on appeal, can the appellant claim that essentially the court has lacked subject matter jurisdiction to impose the writ obligations? Why does preservation prevent us from considering an issue that seems arguably jurisdictional?
And to tag on to that question, isn't this an issue the garnishee would raise?
Well,
the writ is directed to the garnishee, and it discharges the garnishee from so isn't it the garnishee who would raise it?
Well, the garnishee has not raised it, and it only discharges the garnishee from liability. And I think the case law is quite clear that it does not, that successive writs are permitted, and that's actually a Florida Supreme Court case in the Miami Herald. So those could be filed to correct and cure any deficiencies. And in fact, in the Miami Herald case, that Florida Supreme Court case gives us maybe a little bit of guidance, because what it does say is that it resolved an issue on appeal because it had been preserved throughout the litigation. Therefore, the court didn't say this was some unwaivable determination regarding the dissolution. In that case, I
just don't know what to make of the language that says shall be discharged from further liability, automatically dissolved. Like nobody has to do anything. It just happens.
Well, I think that that's the case as to the garnishee, but not as to liability. And
no, I understand that.
Yeah, and I think the case law is quite consistent in both the Ackerman case, the Kane case, that allows a new writ to be issued to correct and cure any of those technical violations.
Right, I understand that, but we're not here on one of the new writs, are we?
The new writ, no, because none of these issues were raised.
Weren't the writs at issue here, aren't they subject to this provision? 77.075. Aren't they subject to that?
Yes, but I do believe that this is error invited by the appellant as well and should not get to benefit from it.
Well, how do you get around the statute?
Well, I think that the appellant repeatedly asked the court to rule on the claim of exemption, and now complains that the court ruled on the claim of exemption, despite having.
I understand that. I just don't know how that fits. I don't know where that fits in with what the statute says.
Well, I do think that any error could be waived, and they should not be able to benefit from errors that they make themselves and invite the court to make.
So let's say you prevailed on appeal. You could go back and try to execute on these writs, and the garnishee then couldn't come in and say, "Oh no, that writ was dissolved."
Well, there'll be a new.
The garnishee has lost their opportunity to say no.
Well, the garnishee has not objected here, and the garnishee is not here.
Because you guys are still fighting over head of household.
Right. Well, but new writs have been issued to the garnishee to hold on to those funds.
I thought there was some case law that the statute appears to be self-executing and mandatory, but I guess as a matter of practice, there are some trial courts that sort of give somebody an opportunity to cure the defect before dissolving the writ. But I'm not aware, even if that's proper, I'm not aware that any of that happened here anyway.
that there were new, I'm sorry, Your Honor, I want to make sure that I understand your question.
Well, as I
So there's
understand,
three, oh, go ahead,
as I
Joe.
understand Judge Kelly's position, the writ is mandatorily discharged, correct? That's, can we agree on that? To the extent there's any practice by a trial court to sort of give somebody another chance to correct the deficiencies before discharge, none of that happened here as to the existing writ. Is that correct?
Correct.
Okay.
Yeah. Right. There's been no discharge at this point. The court ruled on the claim of exemption.
So there's been a final judgment as to the three writs, right? There's three writs.
No, there's been no final judgment as to the writs. There was a claim of, there were claims of exemption.
It's just a denial of a.
Yeah, and actually there was a motion for final judgment as to one of the writs. That's the International Spinal Surgery PA entity owned by the appellant, because that they never filed a claim of exemption, and the garnishee never answered to that entity, to that claim of garnishment.
So let's say we do affirm, it goes back and they're 77.07 subsection 5 has still not been complied with.
It would be complied with the new writ that has been, that new writ of garnishment that has been issued.
You're at the end of your time if you'd like to wrap up.
Yes, Your Honors, thank you. The appellant here is not an honest debtor, and the court had competent, substantial evidence to support his opinion. And to the extent that there's any merit to any of the claims raised on the procedural irregularities, we respectfully request to cure those deficiencies and ensure that this determination is made on the merits and adjudicated on the merits and not elevating form over substance. Thank you, Your Honors.
Thank you. Ms. McDonald?
Thank you, Your Honor. To start with, Your Honor, asserting your rights under Florida law does not make you a not honest debtor, okay? That has been repeated throughout this, and to be honest, it's very, very frustrating. There is no evidence that my client is not an honest debtor. What opposing counsel was referencing was in the lower court, they were not only garnishing his wages, but then they were attempting to garnish his remaining wages that are protected under Florida law. And so he was trying to stop that. That's not an issue here. I just needed to mention that on the record to clear it up. My client is a well-renowned, world-renowned spinal surgeon. He is, taking care of his family and asserting his rights under Florida law. He is not a dishonest debtor. Judge LaRosa, to answer your question, I believe that the procedure and the way that it works is that these writs would need to be dissolved. Then in order to fix any of the procedural irregularities or problems, they would have to file new writs. So what would happen would be is the writs would be dissolved, the money that was being held would be dispersed, and then they would have to start over, okay? So it's not that they get a chance to fix it until, these writs I think are broken, as they say.
So let me ask you this. So whatever happens after the mandate, whatever we decide to do, leaving that aside, you're here and you're here telling us to tell the trial court that the writ should be dissolved for two reasons. One, the 6 months elapsed without a motion for final judgment, and two, that the responses to the claims of exemption were untimely or were unsworn. But you did not present that to the trial court. Why would we entertain that? I mean, in other words, the trial court did not err based on an error that was preserved, and so whatever happens after the mandate, if we were to decide to affirm, could be sorted out by the parties that are before us now. But why should we entertain something that was not preserved?
Your Honor, actually, what I'm asking first and foremost is for a finding that on the face of this order, the court applied the wrong legal standard.
Well, we don't do that. We don't provide advisory opinions. Well,
it's not an advisory opinion. It's reversing because there's clear error in this order. The order says on its face.
Oh, I see what you mean. In other words, but I wasn't talking about the merits.
Yeah, and
I
so
was talking about your procedural
what
arguments,
what
because
I'm
that's what
asking-
Judge Kelly was talking about.
Yeah, but first and foremost, what I'm asking for, if I could get
Got
my
it.
wish.
So on the merits, let's say,
Yeah.
leaving aside the procedural arguments, he made a mistake because he relied on the fact that there was no legal obligation. So what about on the
He didn't rely on
procedural?
that, Your Honor. The court relied on that. I'm sorry, I misunderstood what you were saying. Exactly, because on the face of this order, the trial court specifically relied on two things. First, he relied on the fact that he didn't have a legal obligation. That's an incorrect standard of the law. Under the terms of the statute and the controlling case law, and as Your Honor was pointing out, it says in the statute who is providing is, and it also says for a child or dependent. This is a child and he is providing. And under the state of the case law and the binding precedent here, not binding, I'm sorry, but the case law that's out there, that qualifies him as head of household. In addition, on the face of the order, the judge did not make any determination that there was a credibility issue. If you read on the face of the order, he based the face of the order on that mistaken legal principle. And also regarding the wife and children, Dr. Maxey, he did not issue this order based on a determination that she was not dependent. He says specifically in this order that
Well, real quick, since you have not much time left, you're the appellant, and I understand your argument there. But I had a discussion with your opposing counsel about the fact that there was, and she seemed pretty confident that there was not evidence adduced that he is providing, in the present tense, is providing, which but rather the evidence to support that he is providing one half of the support was all retrospective, meaning he had obligations in the past.
I believe that's incorrect, Your Honor. If you look at the record evidence, which starts around Appendix 262, I believe, there's the affidavits, and then in addition, attached to that are other things showing the support. And more importantly, we have an affidavit from his son. And the affidavit from his son said, my father is paying my expenses. That's in the record. And that was a current is, not something in the past. The affidavit from the son said that he was. And we were going to bring the son in for testimony, but the court issued that determination that it wasn't going to hold a hearing. And I just want to touch on that very briefly. The transcript of that hearing where that took place, you can see from that we did not waive our right to a hearing if there was a factual determination that needed to be made. If you look at the transcript in particular, it's
Ms.
in the
McDonald,
record.
please use this time to just wrap up.
Okay.
Finish your answer, but your time is out.
Okay,
So-
thank you, Your Honor. Just simply wanted to say, if you look at the sub-app, page 340, what the court said was that it would hold a hearing if there was a factual issue that needed to be determined. So we didn't waive our right to a hearing. We relied on the trial judge doing the right thing and applying the applicable law. And if he had done that, then there didn't need to be a hearing because the writs should have been dissolved.
Okay, thank you. Thank you both. And that
Thank you.
concludes our session for today. Court is adjourned.
Thank you, Your Honor.